The committee interfaced with 224 stakeholders, clustered under 60 groups drawn from diverse sectors. In the diaspora, the Global Forum Uganda Diaspora Council, whose memoranda included views of Ugandans drawn from 32 countries across all regions that gave their perspectives on the bill. In addition to the hearing from stakeholders who appeared before the committee also took into account the perspectives shared by His Excellency the President in his guidance to the nation through his letter, particularly that was addressed to the Bazuku regarding the bill. Following these engagements, Right Honorable Speaker, the committee held further sittings during which the learned Attorney General responded to the stakeholder concerns and proposed refinements to the bill. The interactive process ensured that the review incorporated both legal scrutiny and practical implementation considerations. This structured approach, characterized by open invitations, dedicated submission time, inclusive hearings, responsible dialogue, demonstrates that the committee's work was informed by a wide participatory and national representative consultation process. The stakeholders the committee interfaced with include the following. It is important, Right Honorable Speaker, that this goes on record. We have clustered them like this. We had stakeholders under government and public institutions. These are actors with statutory mandates that include Bank of Uganda, Financial Intelligence Authority, National Planning Authority, Uganda Human Rights Commission, the parliamentary committees. We also had another cluster of legal and professional bodies and organizations that focused on the law, like Uganda Law Society, like East African Law Society, the Law Development Center, Center for Constitutional Governance, that had in their entourage former members and former ministers of government. Independent legal and legal practitioners who forwarded multiple submissions. We had political People's Congress appeared and gave their views. And the leader of opposition also appeared and gave his views. I'm mentioning it for the capture of the handset. We also entertained private sector and business associations that include the Chamber of Commerce, Kampala Arcade Traders Association, Kampala City Traders Association, Uganda Small Scale Industries Association, Uganda National Traders Association, the Gen Z Business Owners Association, Innovation Village, the startup ecosystem, and the independent private sector consultants. We did not stop there. We entertained financial, insurance, economic sector actors. These include the sector-specific institutional stakeholders that include Uganda Bankers Association, supervised financial institutions like banks, mobile money operators, via sector submissions. We also entertained Payment Service Providers Association. We also entertained Uganda Forex Bureau and Money Remittances Association. They too appeared and gave their views. We also considered digital, telecom, media actors in communication, broadcasting, and digital economy, include communication sector operators, National Association of Broadcasters, media practitioners, journalists, and journalism practitioners. We also entertained the civil society and non-government organizations, both domestic and international civic actors. The team, international NGO community, collectively represented. We did not stop there, Right Honorable Speaker and Honorable colleagues. We entertained the labor, religious, and social institutions that include NOTU, that include Interreligious Council of Uganda, that include Muslim Organizations Coalition, and other faith-based organizations. We entertained health, scientific community, and public health research institutions, e.g., Uganda Medical Association, Uganda Virus Research Institute, Peoples Living with HIV advocacy groups. We also entertained education and academic sector that include Makerere University, Academic Staff Association, universities and academic researchers, student groups and members of the guild also submitted. National Union of Disabled Persons of Uganda, Uganda Lawyers Voice on Climate Change, Gender Rights and Advocacy, Climate Advocacy groups. We also entertained diaspora, transnational communities, Ugandan actors, the Global Forum. This is an organization that groups all Ugandans in the diaspora. The Cheyo Association, NUP, NUP Diaspora Chapter, individual diaspora submissions. We went further and entertained professional and individual submissions. These are unaffiliated and cross-cutting. Independent consultants, individual citizens, business professionals, researchers. Right, Honorable Speaker, we consulted documents. Consequently, the committee recommendations reflect a balanced synthesis of stakeholder perspectives in the key findings and salient observations. Right, Honorable Speaker, permit me to present key findings and salient observations on the Sovereignty Protection Bill of 2026. Introductory consideration, looking at the scope and interpretation of Clause 2. Before presenting its findings, the committee found it prudent to clarify the key interpretive issue of Clause 2, which is application of the bills or public decision-making for the interest of foreigners. The Attorney General clarified that Clause 2 is meant to limit the bill, not to expand it. He guided that it applies overseas family support are excluded unless in Clause 1 and the expansive list and family connections, such as employees of foreign businesses, traders, and those receiving support from relatives abroad. The Law Development Center noted that that Clause 2 does not distinguish harmful actions from lawful ones. So the people could be held liable simply because of the associations, not because they caused any actual harm. This divergence, Right Honorable Speaker and Honorable colleagues, reveals a fundamental issue. The intended limitations of Clause 2 are not sufficiently clear on the face of the law, creating uncertainty as to the boundary between harmful foreign influence and legitimate activity. While the Attorney General maintains that Clause 2 limits application to specific regulated activities, stakeholders consistently note that this limitation is not clearly reflected in drafting. Therefore, the committee found that the line between harmful foreign interference and legitimate activities is unclear. Clause 2 is meant as a safeguard, but not effectively to limit the bill. This gap policy and the law shapes all the committee's subsequent findings. 5.2, understanding sovereignty. We looked at what the 1995 Constitution says